Welcome to this video series on the East Asian states' leadership in international law. My name is Seok Lee, and I'm Professor of International Law at Inha Law School, which is located in Incheon, Korea. Before getting into this first lecture, I'd like to give you a brief introduction about myself. I'm a graduate of the Korea University, where I received my undergraduate law degree, and then went to receive the Master of Law degrees from Korea University, the University of Minnesota, and NYU, and finally my doctorate from the Oxford University. I'm the general editor of the Encyclopedia of Public International in Asia, co-editor-in-chief of the Asia-Pacific Journal of the Ocean Policy, and Asian Yearbook of International Law. Since the end of the Cold War, Northeast Asia has been one of the most dynamic and dangerous parts of the world, encompassing the People's Republic of China and North and South Korea and Japan. The region has undoubtedly taken on greater global geopolitical and economic significance. The region is now home to two of the three largest economies, for example, the China and Japan, in a world, and with the inclusion of the South Korea, account for about 20% of the global gross domestic product. With the exception of North Korea, all of the countries in the region experienced, or in the case of China, currently experiencing the rapid economic development that has resulted in Northeast Asia accounting for 1/5 of the world production, 1/6 of the world trade, and about 1/2 of the world foreign currency reserves. This great economic transformation is accompanied by the tremendous political forces that animate the region. During the early part of the 21st century, Northeast Asia has seen Chinese ascendancy from regional hegemon to a global power, challenging the United States and the European Union. The region has experienced tensions over nuclear weapons on the Korean Peninsula. There is a more open talk about possibility of Korean unification and its prospects for the region. Japan has made clear that it desires to validate itself as a legitimate international leader with a permanent seat on the UN's Security Council, yet there continues to be lingering impact of old conflicts between Japan and her neighbors that continue to shape the character and the vulnerability of the relations between Northeast Asian countries. Consequently, the popular narratives of the contemporary Northeast Asia are often described in a context of the political economy of rapid industrialization, or from the point of view of international relations in light of the global balance of power and colder fault line between the actors in the region. The dramatic economic growth of the Japan and Korea during the latter half of the 20th century and the Chinese economy's the meteoric rise in this century has been well documented and researched. Northeast Asia has also been the focus of much study in relation to the geopolitical climate of the Cold War in the context of the conflict between the United States and Soviet Union. While economists and political scientists have made great contributions to the study of the region and its modern history, a frequently overlooked area of study is the function and impact of the international law on the relations of the countries in the region. Indeed, the argument that is being made in the pages of this video lecture is that international law has had an importance, if somewhat muted, role since it was introduced to the region by the West in the 19th century up through the period of the Cold War. It has taken a more significant role in the post-Cold War era, reflecting dynamism of the region and the prospects of establishing the order based on international legal principles. The first part of this lecture is about East Asia's encounter with the modern international legal system. Let me give you the brief introduction of this part. Holding a country responsible for its avoidance of international legal obligations by doing the bare minimum required by international law is very difficult. It is with hope that an accurate understanding of the effectiveness of an international litigation against another state or the states whose application of international laws may pose moral but no legal problems will assist in the development of a stable relationship in East Asia. Based on the GDP, gross domestic product data produced by the IMF, International Monetary Fund, in October 2023, the three Asian state nations, namely South Korea, China, and Japan, hereby referred to as Korea, China, Japan in this lecture, are second in the case of China and fourth in the case of Japan and 13th in the case of South Korea, our largest economies globally. Together, the collective GDP of these three East Asian nations constitutes approximately 23% of the global GDP. These countries are commonly grouped as East Asia due to their shared cultural background, historical relationship, and geographical proximity. Numerous studies have been conducted and continue to be undertaken under the premise of treating these countries as a singular regional entity. This conventional approach serves the basis for multitude of research endeavors that they focus on the interrelatedness of these nations within the regional framework. However, the question remains as to whether these East Asian nations, as members of the geopolitical group that constitutes approximately 26% of the world alongside with the United States and the European Union, are impartially evaluated in terms of a normative standard compared to nations situated in other regions. In response, this lecture aims to assess, from an international legal perspective, whether the member states of East Asia, collectively forming a tripartite division of the world, along with the United States and European Union, are effectively fulfilling their responding roles. This evaluation focuses on whether nations with comparable GDPs are proportionately contributing to the advancement of the international norms, which is the international law, and if they are not, what the reasons are for such disparities. Furthermore, this lecture explores whether the Korea, China, Japan trio can transcend the regional boundary of East Asia and assume a leading role in the development of international norms and international law that correspond to their global standing. Ultimately, the aim of this lecture is to advocate for forward-looking introspection by the East Asian nations regarding the essential prerequisite of universal international norms and international law, including legality, morality, and contemporaneities. Embedded in the cultural fabric of East Asia lie Confucianism, a philosophical system emphasizing respect for authority and the pursuit of harmony within hierarchical relationship. Such values have permitted the region's approach to maritime governance, leading to quest for harmonious intersections and adherence to mutually agreed upon rules in oceanic affairs. Moreover, East Asia's historical emphasis on collective harmony and diplomacy has profoundly impacted the establishment of the multilateral agreements and organizations, reshaping the region's cooperative approach to addressing maritime challenges. Beyond the philosophical tenets, Asian maritime traditions embedded in Eastern culture have significantly shaped customs and norms concerning marine resource management, the fishing rights, the sustainable practices, and the preservation of traditional fishing grounds are manifestation of this cultural heritage in maritime affairs. International cases addressing Japan's whaling activities have demonstrated how Asian traditions and cultural perspectives intertwine, influencing a nation's stance on marine conservation. Moreover, East Asia's cultural landscape is adorned with the tenets of the Buddhism and Taoism, promoting interconnectedness and reverence for all life forms. These profound cultural values have inspired the environmental protection and conservation efforts within the region, influencing international cases related to maritime dispute with underlying environment considerations. The cultural influence of East Asia is widely recognized, stemming from the Confucian tradition in China and Korea, as well as Buddhist ideals that originated in ancient Japan. Confucius extolled the virtue of hierarchy and stability, and this reflected the desire to maintain an internal harmony in which participants from the level of the family to empire understood their place in the system. As encounters with the West occurred, colonial traditions intermingled with classical Eastern cultural norms, contributing to the development of nationalist and expressionist ideologies, the first observed in Japan and more recently in China. It is important to note that Korea too experienced an amalgamation of influences from both the Western and Eastern spheres. There is a long-standing debate, however, as to whether an East Asia concept of international exists and what it is. Indeed, while applying a general understanding of international to actual cases, international lawyers in East Asia have encountered notable challenges in identifying the pertinent source materials and addressing specific aspects, leading to difficulties in conceptualizing the relevant issues. Given the complexity of the ascertaining a cohesive East Asian perspective on international law, the following essential inquiries arise concerning the plausible East Asian conception of international law and its application. The questions is like that. The first, to what extent can international law accommodate cultural distinctions between Western and Eastern states? The second, what approach do East Asian states take regarding the cultural influence, if any, in their interpretation and application? And third, if the distinct East Asian approach to international law exists, what is its contribution to the development of international law in East Asia and the general development of international law? The comprehensive exploration of these questions is beyond the scope of this lecture. However, a more modest approach may involve investigating how East Asian states are applying international law in their domestic legal systems and in their foreign relations. Specifically, such an inquiry aims to determine whether a distinct East Asian approach to international law emerges, either uniquely or shared among East Asian states. Consequently, this approach seeks to cautiously propose initial conclusions regarding the potential factors accounting for any similarities among East Asian states in their perspective on international law. Thank you very much for your attention for this part. Thank you.